Welcome to the Court of History. I'm Sean Wilentz with my compadre, Sid Blumenthal. In our Thanksgiving edition, part 2 of our Thanksgiving edition, talking with Jeffrey Rosen, the CEO and president of the National Constitution Center in Philadelphia, talking with him about his latest book, In Pursuit of Liberty, all about Hamilton and all about Thomas Jefferson. Here we are on the eve of the bicentennial, talking about the things that really matter or that are most lasting about the revolution, which are the ideas that gave birth to this country. So we were ending last time with all of the ways in which, in the era of the Civil War, that Jefferson and Hamilton's ideas were kind of permutations and combinations. Different sides are picking different parts out of them to justify their own points of view. With Lincoln as the great Democrat, of course, standing up for the idea of all men are created equal, but at the same time, John C. Calhoun from becoming a great nationalist to becoming the great sectionalist. He was a nationalist in that he became a Southern nationalist in the end, but that's another kind of nationalism altogether. It's not what Hamilton had in mind. But then we went to Crowley, and I'm wondering if we can update this a little bit. I mean, let's carry it forward. You had mentioned that there was obviously Lincoln, but other presidents that may have read these two guys and seen it as central?
Well, it starts with John Quincy Adams and Martin Van Buren, who write the first political histories of the U.S. Adams, in his talk on the Jubilee of the Constitution, tracing the rise of the parties back to Hamilton and Jefferson's clash over national power and states' rights, and Van Buren in his comprehensive history of the political parties, tracing their rise to the clash between democracy and aristocracy. But without going to all the presidents in between, including James Garfield, who read the works of Hamilton and led a Reconstruction-era revival of his ideas, the big president after TR, who was transformed by a Hamilton and Jefferson book, is Franklin Delano Roosevelt. And the book was by Claude Bowers, and it was Jefferson versus Hamilton, the battle between democracy and aristocracy. And FDR reads this book. He says that he writes the only blurb that he's ever written, and he invites Bowers to speak to the 1928 Democratic Convention, where there's a stampede on behalf of the Jefferson of democracy versus aristocracy. And then FDR wins in 1932, and he proceeds to reinvent the Democratic Party, making Thomas Jefferson the patron saint of the New Deal. And this can only be described as an act of chutzpah, because it is impossible.
FDR in New York would have known what that meant.
He would have known. And in fact, Alexander Hamilton would have known what that meant, because, as I note, some historians think Hamilton may have been Jewish. His mom may have converted to Judaism to marry Levine, exactly. But FDR's let's call it achievement is remarkable. He's emphasizing the democratic rather than the libertarian Jefferson, and he puts Jefferson on the nickel, and he builds the Jefferson Memorial, and he surrounds himself with Jeffersoniana to the point of dying on Jefferson's birthday with an undelivered speech about Jefferson as the prophet of the post-war order. It's just a remarkable identification. FDR was deeply drawn to the idea of Jefferson as the democratic aristocrat who was both a great gentleman and a great commoner, a way that FDR thought of himself. And it was a way of rebranding the Democratic Party, emphasizing the democratic aspects of its founder. An incredible achievement.
It was the Democratic Convention book of 1936.
Wow.
Now look at over here.
There it is.
Amazing, Sid. That's incredible.
All right.
It's so cool.
It's a this is what FDR did. It's a picture of him and Jefferson. And
H.N. won in 1936.
Yeah.
Oh, my goodness. That's
and this
incredible.
was what a convention book handed out at the Democratic Convention of 36. And it says the Democratic Party, Jefferson, Roosevelt.
Just incredible.
And it's year 6, so it's really important.
Yeah. Right. Do you have other swag like that? I mean, he just put Jefferson everywhere.
I'm in Washington, so I can go down to the Jefferson Memorial and see the other FDR swag about Jefferson.
Yeah. Just incredible.
But historians these days would mostly say that FDR was more of a Hamiltonian because of his use.
He was the great Hamiltonian.
Of course. And he didn't want to embrace it openly because Hamilton is politically toxic and is the prophet of the aristocrats and the moneyed elite. And yet the New Deal, as Arthur Schlesinger said, if the first New Deal breathed the spirit of Hamilton, and the second New Deal breathed the spirit of Jefferson and Brandeis. And by decentralizing the agencies, FDR was able to persuade the Supreme Court to uphold it. He was entirely flexible in his approach to federal power, but it's also a reminder that he wasn't simplistic in just expanding the post-New Deal administrative state. The complicated arrangements that he came up with were ones that both Hamilton and Jefferson might have approved of. And in fact, this, of course, raises the question of the central constitutional battles we're having now on the court, including the constitutionality of the independent agencies. And as the court prepares to overturn the Humphreys executor case, we can remember that it was written by Louis Brandeis for a unanimous court in the 1930s. Brandeis, the great Jeffersonian, saw no inconsistency between agencies and the ideals of Jefferson because, as Brandeis put it, the point of the framers, by which he went Jefferson, was not efficiency but liberty. And independent agencies, by checking executive power, were necessary to protect liberty rather than a threat to it. It reminds us, as you both are exploring on this podcast, that there is no single, simple, original understanding of most of these constitutional texts. To presume to invoke Hamilton and Jefferson on behalf of either of them is generally inaccurate, but it does come down to liberal versus strict construction, and a Hamiltonian vision of executive power would uphold the executive and independent agencies.
Mm-hmm. Yeah, but the unitary executive is not necessarily Hamiltonian. It is a new idea that's been created in recent times, and it's not at all what FDR, the great Hamiltonian, designed. And as you point out in the Humphreys executor case, a New Deal case, it was in the spirit of Brandeis as well. So there's a kind of merger of Jeffersonian and Hamilton ideals in the creation of what is called the administrative state, what we call the American government, which the Supreme Court, through the unitary executive idea, if it can be called that, is trying to destroy, really.
Well, it's a really important intellectual and judicial history to trace. The unitary executive theory was first proposed in the 1980s by young lawyers in the Reagan administration, including Antonin Scalia and a young John Roberts. And the unitary executive theory first was in the context of Ronald Reagan's declaration that he had left the Democratic Party in 1960 because it had abandoned the principles of Jefferson and limited government. And he decided, when he came to rebrand the Republicans as the party of limited government rather than oligarchic power, and to question the post-New Deal administrative state. And the foundation for the judicial challenge to the post-New Deal administrative state was a Jeffersonian view of congressional power, but a Hamiltonian view of executive power. And in particular, through executive orders and deregulation to strike down many of the regulations, and by judicial appointments to argue that elements of the New Deal, and in particular the Great Society, were unconstitutional. It's the phrase unitary executive theory comes from an invocation by Hamilton in the Pacificus Letters. So it claimed Hamilton's views on foreign policy as its core, but immediately a difference of opinion emerged among the Supreme Court justices who were appointed to strike down the administrative state, in particular between the Hamiltonian Justice Scalia and the Jeffersonian Justice Thomas. I was really struck in looking into the history to see Justice Scalia openly embracing Hamilton as his model, championing judicial deference to regulation in the Chevron case, and also suggesting that a proper construction of congressional power should give Congress broad authority to legislate. This contrasted with the second generation of originalists led by Justice Thomas, who suggested that much of the post-New Deal administrative state was unconstitutional and wanted to and strike down Congress's power to regulate medical marijuana, where he diverged from Justice Scalia, and ultimately overturned the Chevron case after Justice Scalia's death. I think this division hasn't been adequately attended to in the debate over originalism. Original public meaning, which was the catchphrase that conservatives embraced for interpreting the Constitution, concealed the fact that there's a basic debate over original public meaning, and that has to do with whether the power-granting clauses of the Constitution should be liberally or strictly construed. And on that question, Justices Scalia and Thomas disagreed, with Justice Thomas embracing strict construction and Justice Scalia embracing what he called fair construction, a phrase he got from John Marshall, who was, of course, a great Hamiltonian. For me, the bottom line of this inquiry is that there is no single original public meaning of the Constitution on any of the really contested questions that the court is deciding. It all comes down to liberal versus strict construction. And on that question, including on the constitutionality of the administrative state, conservatives disagree.
Yeah, I want to have you relate an incident of in which you spoke to Scalia, Justice Scalia, who you knew, about Brown v. Board of Education. And it's an incident that bears on what you just said about, and raises the questions of whether or not originalists are ultimately results-oriented and use this as a kind of ideology to justify what they're doing, and whether or not there's any coherence to any of this. But please tell us about your dinner with Justice Scalia and discussion about Brown v. Board of Education.
Well, it was indeed presided over. It was my friend Zeke Emanuel had a bet with Justice and Scalia. Justice Scalia lost, so the punishment was to go out to dinner with Zeke. Zeke nicely invited me. It was, in fact, the only time that I met Justice Scalia face to face. So he wasn't a friend, but he was. I was honored to have the chance to talk with him, and he was a delightful dinner companion. And there was some red wine, and he was telling stories. And I think we talked about opera, which we both love. And at some point in the evening, I just screwed up my courage, and I said, Justice Scalia, there's a question I wanted to ask you. You say that you are an originalist, but Brown v. Board of Education is completely inconsistent with the original understanding of the Constitution, because folks stood up in Congress and said, don't worry, this won't end school segregation. What's your response? And he paused for a moment, and then he threw back his head and laughed and said, you know what? No theory is perfect. And I just thought that was a wonderfully candid response from the great originalists, that it couldn't, in fact, solve the essential question that everyone agrees that the theory can't survive unless it can answer. Does that mean that the whole enterprise is hypocritical? When you see how, in what a result-oriented way all theories of interpretation have been deployed throughout history, both originalist and non-originalist, I don't think you can say that. And of course, the originalists have a response, which is to shift the level of abstraction. In fact, we care about the original public meaning of the Equal Protection Clause. And some, including Justice Thomas, say the original public meaning originally claimed that the Equal Protection Clause was colorblind in all circumstances. I don't believe that that is a plausible construction of the original public meaning of the Equal Protection Clause, because no one at the time thought that it required colorblindness for all state action, but only for civil but not political or social rights, as Justice John Marshall Harlan says in the Plessy dissent, which originalists quote as their text. So it's only by increasing the level of abstraction that the text is construed that you can make a claim about its original public meaning. And at that point, I don't see why you should talk about it as original public meaning at all. You're just making a claim about the meaning of the text.
Yes.
And that really does suggest that originalism can't answer the primary question. And I have not heard a response that I found persuasive to that challenge. But that's why really originalism is not about original public meaning. I think it's about liberal versus strict construction, and that question there was no original public meaning of whether the Constitution should be liberally or strictly construed. This is the question about which Hamilton and Jefferson essentially disagreed. So it's really the claim that there's a single original public meaning that is not supported by history, and I think you have to concede that the meaning was essentially contested from the start.
In the time we have left, though, which is growing shorter and shorter, and I hate it, we should go on forever. I wanted to ask about another case, another controversial case, and that was the Supreme Court ruling in Trump v. U.S., in which originalism doesn't even seem to appear. There seems to be no original meaning that's attached to all of that. It seems to be, well, what did you make of that at Hamilton versus Jeffersonian terms? What would they have made of that decision? This is the presidential immunity decision.
Well, neither Jefferson nor Hamilton talked about presidential immunity, a phrase that doesn't appear anywhere in the text. And Jefferson, of course, is determined to create a constrained executive who can not threaten the liberties of the people because executive power is always essentially corrupt. And Hamilton, too, feared a corrupt executive, believed that increasing its power would decrease its tendency to court the people. In fact, at the dinner party that defined America, after the exchange about Julius Caesar, John Adams at some point says, "Purge the British Constitution of its corruption, it would be perfect." And Hamilton, according to Jefferson, at this point in the evening, blurts out, after another pregnant pause, "Purge it of its corruption, and it would lose its perfection. As it is the greatest constitution in history." By that, Hamilton was using corruption in the sense that David Hume used it, as a way for the executive to have influence over legislators by giving them offices in order to shore up his power. It was the opposite of financial corruption. And in fact, Hamilton explicitly in the Federalist Papers is concerned about financial corruption or corruption of foreign courts, and says that the remedy is amenability to criminal prosecution followed by impeachment. It is quite obvious that Hamilton never intends the president to be unaccountable either to prosecution or to impeachment.
Or for crimes or attempted overthrow of the government itself.
Well, I think that's a fair conclusion. I don't know that Hamilton it addresses that particular possibility, but absolutely amenable to prosecution.
Well, Hamilton was certainly against insurrections under Washington, and
yes, but the question, there is a lot to say about Hamilton and Jefferson on insurrection, including the fact that Hamilton always wants to lead a military parade with himself at the head to put down the insurrections, and Jefferson wants to pardon the insurrectionists, and at times almost endorses the violence of the French Revolution. Whether Jefferson would have endorsed January 6th, he would have endorsed pardons, probably, although he doesn't endorse open lawbreaking. But the difference about Jefferson and insurrection is he thinks that access to media and newspapers will allow reason to spread and allow insurrectionists to make accurate decisions about the facts and to be guided by reason rather than passion. And he would not have known what to make of a world of conspiracy theories where people are rising up based on false evaluations of the facts. But on Trump v. U.S., the defense of the majority is one that Justice Alito made during an oral argument, and Chief Justice Roberts essentially embraces, which is that we don't want presidents to prosecute their predecessors, that broad immunity will avoid criminalized prosecutions, which the founders were determined to avoid. At that point, there's a counter that far from avoiding criminalized prosecutions, the decision has encouraged them by allowing the president to prosecute his enemies without fear of being held accountable. That's an empirical debate that we're not going to solve right now. But the relevant point is that the majority defends Trump v. U.S. immunity in pragmatic, not originalist terms. And the dissenters, led by Justice Sotomayor, say this has turned the president into a king. This is the fulfillment of Hamilton and Jefferson's worst fears. And interestingly, both Chief Justice Roberts and Justice Sotomayor cite Hamilton in their opinions?
I'll say, Trump, while citing Andrew Jackson as a precursor, because he was told to do so by Steve Bannon, and has no idea who Jackson was, has given that up. And he seems to be neither tied to the Jeffersonian nor the Hamiltonian tradition, but something that they both warned against. He's from a different line of demagogues and rogues in American history, and he's not quite them either, because he's not quite queuing on because he's for the rich, and he's not quite Aaron Burr because
Aaron Burr, right?
He's, among other things, he lacks the Princeton education. But yeah, so, and he's not, if you go to the bottom of the barrel of presidents, they were failures, but they were not lawless. There may have been some corruption among, in their administrations, but no one, Franklin Pierce was not lawless. As bad as James Buchanan was, he was not lawless, although he may have supported some of it in Kansas, and so on. I mean, this is something that is unique in American history, in my view.
It's a really important discussion. I end the book by asking whether President Trump is Julius Caesar or Andrew Jackson. And his critics say that he's Caesar, and that by consolidating power in the executive, combined with a supine Congress and a deferential court embracing a broad vision of the unitary executive theory, he's achieved the authoritarianism that both Hamilton and Jefferson feared. And the case for him is that he's Andrew Jackson, and that by using strong executive power to attack the administrative state, as Jackson attacked the bank, to fire civil service officials and to reinstitute the spoils system, and to channel populist resentments against elites, he's the successor of Jackson. Lots to say on both sides of that question. I feel that it is too soon to make a judgment about whether he's Caesar or Jackson. I also think it's highly significant that Jackson, in the end, favored union over secession and nullification, and gave his noble toast to union and liberty. And as to whether President Trump will ultimately favor union over division, as President Trump so wisely says, we'll see.
I will add that when Abraham Lincoln faced secession, one of the two documents he consulted was Andrew Jackson's proclamation on nullification. And he was indeed a nationalist in a way that defies, people couldn't believe it, but that's central to what Jackson's about.
And that's why I can add, Sean, he kept a portrait of Jackson left over from the previous administration in his study.
Lincoln turns to Jackson more and more over the last, just before secession. At the same time, he's picking up on Jefferson. So it's an interesting synthesis. But this is a conversation we're going to have down the line. Jeff, consider yourself a friend of the court, not just a friend of individually, but a friend of the court of history. We'll hope to turn to you again. But for the time being, for the part 2 of our Thanksgiving session, don't forget to subscribe. Subscribe, please, to Legal AF. And on behalf of my co-host, Sidney Blumenthal, the court is now adjourned.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.